Whoever happens to scroll in.
Hey.
That's good. It was all right. You're a little bit older. Well, maybe not. Maybe not.
Good morning, everyone. I'd like to welcome all of you to the October meeting of the Sheriff's Civilian Oversight Commission. This month, I want to just acknowledge that it's Domestic Violence Awareness Month. Some of us are wearing purple. Just to remind everyone that we want to provide a safe and encouraging environment for all to be heard, and for the vision, and also for the business of the commission to be completed. So just a reminder that as of our last meeting, public comment is now limited to 2 minutes, and you may only speak on 3 items for a total of 6 minutes. Let's begin with a moment of meditation. Starting early, driving from everywhere, just kind of like come into the space to be present together. I'd like to ask Commissioner Harris to lead us in the Pledge of Allegiance.
Please stand as you are able and your conscience will allow, and recite with me our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic over which it stands, one nation, under God, indivisible, with liberty and justice for all.
I want to remind folks that if you would like, as you come up and speak, if you would like your name to be placed in the minutes, please indicate so that Ingrid or Christine from staff know that you want to be identified in the minutes. Let's turn to agenda item number 1, which is the approval of the September 17th, 2019 meeting minutes.
Move approval.
Second. We have a second. Everyone in favor?
Aye.
Any opposed? Thank you.
Yeah, one speaker.
On the minutes. Okay, sure.
Greg Allen.
Good morning, everybody. Mr. Muller, I'm glad to see you here. He reminds me he submitted a letter that I didn't get a reaction to on changing 4 of the felonies to misdemeanors. I wondered if we have any results in his request to change that. Anyway, your minutes included sign changes. I disagree with your sign changes. If you think they're offensive, then you need to go to therapy and handle it that way. It's all right to have free speech, and the signs don't hurt anybody. They send a message loudly and clearly. It's part of free speech. If you can change the size of the sign, then you can change it again. The little index cards, next. Is that what we're gonna move to? No, take that out. I want my signs any size I want. So you guys tolerate it, all right? Like I said, if you need to go to therapy, handle it. The other thing is the minutes. You got no problem with letting people talk too long, and now you want to change how long we get to talk to 2 minutes. That was also in the minutes. That's an outrageous assumption on your part to change minute times, because guess what? It was set at 3 minutes for a reason. And you don't get to change that. So just take that out too of the minutes. Don't change it back to 3 minutes. You can tolerate 3 minutes of somebody else telling you that you're messing up. And that's all it's about. Criticizing you. Now change it back to 3 minutes. I don't want to tolerate anything that you guys have to say about leaving it in at 2. It's going to be 3. Unless you want to drag us off here. Because I'm going to exercise my right to 3 minutes, and you can just enforce me off my spot. You think you can do that? Go ahead. I've seen you in the past do nothing.
Thank you. Okay, let's move to agenda item number 2, which is discussing the recent California Supreme Court decision of ALAS versus the Superior Court. It was issued in August of 2019 regarding the department's Brady list. Back in March of 2017, the Commission adopted a resolution in support of the then Sheriff McDonald's Sheriff's Deputies Misconduct List, known as the Brady List, giving it to the District Attorney's Office. This is an extremely important issue, for as the resolution states, violations of the Brady rule can lead to wrongful convictions and threaten the legitimacy of the criminal justice system. I want to thank our ad hoc committee for their work on this resolution, and especially Commissioner Kennedy, who was the principal author of it. And with that, I want to turn to Commissioner Kennedy for his comments.
Thank you. We're offering this resolution to address a very important issue, and that is there currently exists a Brady list of 300 deputies that was created, and it was not turned over to the district attorney's office because at the time there was a lawsuit questioning whether or not a Brady list could be turned over to the prosecutors. Now, we all know from many comments that due process requires that the accused be given all exculpatory information, and exculpatory being legalese for information that tends to show innocence or information that impeaches or calls into question the credibility of witnesses for the prosecution at trial. So we're talking about a very important issue. Recently, the California Supreme Court, in the case of ALAS versus Los Angeles Superior Court, held that, unanimously held that the sheriff can compile such Brady lists, and alerts to the DA's office are not prohibited at all. And I want to add that the court talks about confidentiality, which is always an important issue in police personnel files, and how it creates, quote, insiders and outsiders. And that for the purposes of a Brady list, the prosecutor's office, the district attorney, is an insider, and it doesn't violate confidentiality to give a list like that to the prosecutor, because the prosecutor is part of the prosecution team, all of whom have a due process obligation to produce Brady material to the accused. And the court specifically rejected the notion, which we have sometimes heard, that the sheriff's department does not have a Brady obligation to turn over exculpatory information. And so we're bringing forth this motion which asks the commission to essentially resolve to tell the sheriff that the sheriff's department should give the Brady list to the district attorney's office right now. There's no longer any legal reason that that should not be done. And there certainly are important constitutional reasons to do so. I think all of us, no matter what our background, can agree that we should follow due process of law and do whatever we can possibly do to ensure that people are not wrongfully convicted and that we don't continue to have these judgments and settlements of millions of dollars for the wrongful convictions, the money being the least important part. The most important part is that these Brady violations are one of the leading causes of wrongful convictions. As someone who has represented a person who was wrongfully convicted and spent 23 years in prison for a murder he did not commit because of a Brady violation, I really urge the commission to vote yes on this resolution. And the only thing that I wanted to add for our executive director is I wanted to recommend that the last paragraph of the resolution, which is somewhat couched in obscure bureaucratic language, be simplified to state, therefore, be it resolved that the LA Sheriff's Department should give the Brady list to the LA District Attorney forthwith, making it clear that we want that list to be turned over now so that the wrongful convictions and Brady violations don't occur, or at least we do everything we can within our power to stop them as soon as we can.
Thank you, Commissioner. I have a syntax question, but it also might have legal standing. Is it should or shall?
Well, I think different people could have different opinions on that. I think shall is sounds mandatory.
Okay, so
I think law enforcement
let's
understands.
talk about it. Open it up for discussion among commissioners, and then of course I'll invite the sheriff, and then we'll have discussion from the community.
Let me, if I could, Madam Chair. First of all, just on the issue of should or shall, I mean, this is a recommendation to the sheriff. We want the sheriff to do this.
Right.
So it should.
Okay.
We can't mandate the sheriff do this.
Okay.
So I would advocate that we use the word should here. He should do this. That's what we're going to be recommending to him, I believe. But I just wanted to add that this whole subject of the Brady list is particularly troubling, and it underscores that when a deputy's misconduct is such that it renders his testimony in court not credible, that deputy should not be a deputy sheriff. I'm not saying, by the way, all of the misconduct in the Brady list rises to that level. Some of it does, however, by the way, because I'm aware of some of it. Some of it rises to that level. In other words, there are deputies that are on that list whose testimony is never going to be believed by a jury. It's that serious. And that person just should not be a deputy sheriff. So this also goes to the state of the discipline system in the sheriff's department as well. And I just wanted to make that point. And otherwise, I favor adoption of the resolution.
Commissioner.
Yes. One of the things, and I certainly support the resolution and admire the professionalism of Commissioner Kennedy for articulating all of the the absolutely necessary issues. But in addition, I think it's essential that the sheriff comply with the Brady requirements and with the very clear mandate from the unanimous California Supreme Court, because we have all heard and read of what turns out to be horror stories with unlawful convictions based on the fact that the district attorney and actually other prosecutors throughout the state did not have the necessary information that it should have had to turn over to the defense, because it was information that law enforcement kept to itself. We, as a commission, by unanimously recommending this resolution, really take a stand and say, this has got to end.
Thank you. Any other comments? Commissioner Harris?
Well, I'll join with Commissioner Rubin and Commissioner Kennedy and Commissioner Giggins in supporting the resolution. I think it's just based upon the Supreme Court's decision. It's real clear that the department, all law enforcement agencies, need to comply with Brady. And in doing so, I think there are going to be those situations where, through the compliance process, the pitches process will be kicked in. There'll be a chance for evidence of what the nature of the reason these people were placed on the Brady list will come forth. It doesn't automatically mean that a person wouldn't be able to testify, but I think it's absolutely incumbent upon the sheriff to ensure that all parties in a criminal action are made aware of any allegations that might cast some doubt on the veracity of the testimony of the deputy. And then the trier of fact can make a determination whether that is valid or not. And even if they determine it's valid, it's up to the defense counsel if they want to use it. And I have to say, there's going to be some times when it is used, and let the jury then decide who they want to believe. So the reason I'm making my comments is I think there's a overarching fear on the part of some people that this will just cause a wholesale deputies would be just not believed, and I don't think that is the case. People do make mistakes. People come back from those mistakes, but it's incumbent that the trier of fact know that and be able to judge that. So that's why I truly support this. I hope the Sheriff's Department does work with the District Attorney's Office to figure out the best way to move forward with this. Because it's incumbent that all of us as members of the criminal justice system work together to ensure that all people receive fair trials. So I totally support this resolution.
Thank you.
I just wanted to add something. First, I wanted to echo what Commissioner Bonner said about that if a peace officer is dishonest in a definitive way, they should not be a peace officer. That's actually written into state law under 3303.5 of the Government Code, the Peace Officers Bill of Rights, and provides that the Civil Service Commission and the discipline process can hear from an expert witness as to whether or not conduct in question would place a person on the Brady list and what impact that has. And as has been pointed out by Commissioner Harris, there are ranges of misconduct, and some is of the sort that it absolutely must be disclosed to the defense, but nonetheless the law enforcement agency has confidence in the officer, and that is a very different situation. And then of course the appropriate thing is to put the person on the list, turn the information over, and allow the criminal justice system to deal with it. But there are situations where that is not the case, and in those cases we should employ the government code up to and including through civil service and fire when appropriate, and utilize the Brady list, which is not something that was made up. It's in California state law. So I think that's critical. I wanted to add, as I think the motion reflects, and Commissioner Kennedy's comments alluded to, what triggers a Brady list isn't just dishonesty. It includes other conduct which can tend to show innocence. So there are situations in which excessive force can be something that should be on a Brady list. It's a different issue. A person who has been dishonest, it's relevant whenever they're a witness, but as to force, it's relevant in situations of use of force, when they are again involved in a use of force. So the Brady list that has been touted in the past as this thing that we fought over whether or not we should tell the DA is actually insufficient for constitutional standards. And in the long run, the Sheriff's Department should employ a thorough process which identifies all information which should be turned over to the prosecution and should actually implement that. And I think this motion is a step in that direction. But I want to make it clear that process is more involved and intricate than what we have. Whereas it also needs to have the protections that Commissioner Harris talked about, where we don't put information on when it shouldn't, that have been discussed in the Sheriff's Department. But we should not shy away from putting information in there when it triggers a need for the defense to know, both because of dishonesty and because of other reasons related to specific cases. Thank you.
Okay. Thank you. Commissioner Bonner?
I wanted to add one brief point to Mr. Huntsman's comments, which I think are very well taken, that it is a process issue. It actually, it's not just a matter of now, it's a matter of having a process in place. But and there are degrees and gradations of misconduct. Some of it the DA is not obligated to turn over, by the way, and should not. But when you have situations, and when one of these cases involves this, where evidence is fabricated by a deputy, that deputy cannot continue as a deputy sheriff. That deputy is a deputy sheriff, but he fabricated evidence. He's never going to be believed in court. And one of the fundamental job requirements for being a deputy sheriff is to be able to credibly testify in a court of law. That deputy can't do that. That deputy has to be terminated. Okay, or if he's testifying, that information has to be available to the defense, and that deputy is not going to be believed. So if his testimony is critical to the case, that case is going to be acquitted. There's going to be, which shouldn't have happened in any event. And then there's just lying, false reports. Deputy makes a false report to his supervisors or in a report that's going to the DA's office. If that report has material false information, the deputy has to be disciplined and terminated, because he's never going to be able to credibly testify in a court of law. And I just want to make that point. Thank you.
Anyone else? You mentioned Pritchis. For the benefit of the community present, could someone explain Pritchis? Pitches, not Pritchis. Pitches. Pitches.
Pitches is a statutory process. It was triggered in the first place by case law, but it became a statute of California. The Pitches refers to the name from the case, but it's a process whereby exculpatory evidence can be requested, and the defense, and as the prosecution as well, can make a Pitches motion. They show some prima facie case to the judge that there's a reason for it. Then the judge will require personnel records to be brought into court and examine them for exculpatory evidence in a very specific, precise way related to that case, and then turn over information if possible. Pitches was discussed quite a bit in the ALADS versus Supreme Court case. One of the theories from below was that Pitches somehow trumped the Constitution, and the Supreme Court, not surprisingly, said, no, it does not. It's a statute that's meant to enable a process, but the absolute right of criminal defendants to receive exculpatory evidence is independent of that statute, needs to be implemented by the Sheriff's Department or other law enforcement agencies and the prosecution. But Pitches is a mechanism whereby the defense may, or the prosecution may, seek to pull information out that maybe they haven't heard about. But it's not a necessary thing for a defense lawyer to do. They could sit back and wait till post-conviction if they know something's there, not make a Pitches motion, then after conviction point out that in fact something wasn't given to them and get a reversal as a result. So it doesn't in any way prevent the other constitutional obligations that Commissioner Kennedy's talking about.
I just would like to add that PITCHIS is a statute to try to obtain information from a police personnel file. As our IG stated, but it is not as comprehensive as the due process required right to receive all exculpatory evidence under the famous Brady opinion. Brady predated the enactment of predated the PITCHIS opinion and the enactment of statutes. For some reason, the PITCHIS opinion doesn't even mention Brady, but the most important difference is under Brady, an accused does not even need to ask for the information. What's more, make a prima facie showing. The obligation is on the prosecution team, meaning the prosecutor and the investigator is assisting, to produce the exculpatory evidence. And there's also no statute of limitations on that, which PITCHIS also has a 5-year statute of limitations. So it's a broader constitutionally based right that should not be relegated to the PITCHIS procedures.
Okay. No small matter. Okay. I want to invite the sheriff if either of you would like to make any comment before we open to the community, public comment.
Well, thank you for giving me the opportunity to talk. And as you know, obviously this is a very contentious issue. I think the department understands the gravity of your concerns, and we'll take the resolution that was read under consideration. And we also want to conform with our legal advisors. Excuse me. Didn't do that on purpose. I was Siri. Yeah, the department wants to confirm with our legal advisors on how to proceed going forward. And also, we have met with the DA's office to try to come up with some form of a resolution to see how we can move forward in conformance with the law. So obviously, we are very aware of the seriousness of this issue, and we are taking steps to resolve it.
Great, thank you so much. Okay, so can we entertain a motion as amended? And I thought we do a motion and then we, what? Yeah, we do a motion and then we open for discussion. So you trained me well.
Yes.
County people. Yes. Go ahead.
I move that the commission adopt this resolution as amended by Commissioner Kennedy, in particular, the change in the last paragraph.
Second. Do you have a second? Okay, so let's open discussion to the floor, public comment.
We have 2 speakers, Greg Allen, followed by Patrick Braden.
Good morning again. I'm afraid we're never going to be able to hire another sheriff. You're opening up his personal life to something he did wrong. If he did what is considered like a misdemeanor in the sheriff's area, where supervisors don't want to fire him, then we need to protect his anonymity from any or all attorneys. But if he did something wrong, of course, why is he working for us? Get rid of him, fire him, but don't expose the whole sheriff's department to illicit attorneys who are going to have their private information. We need to protect our officers who we put into the situations that they go into. We put them there. Now let's protect their privacy. The other thing is, if you take away a minute here, you can take another minute away there. So when you change the minutes, and we allow you to change the minutes, then you can also change them again. Now, we need to protect our sheriffs. We can't throw out the baby from the bathwater. If you have somebody who rises to the level of incompetence, just fire them. As soon as they get on the Brady list, that's it. They made it to the Brady list, fired. Now, if you have them fired every time, then you're supporting my sheriffs. You're protecting them, because the only people you're turning over evidence or information to is about a fired sheriff. Now, protect the ones who work for us. If they haven't done enough to get on the Brady list, or if they have done enough, everybody on the Brady list, just fire them, so we can protect the good sheriffs and give them the privacy they need to make their families safe. We want to protect their families from exposure. Can't we protect them from exposure? Because that's what you're asking this new Brady law thing to do. I say if you got a Brady law and they reach the level where they get on it, fire them. That's it. Protect the rest of my sheriffs.
Thank you.
Patrick Braden.
Thank you. I came back from my first address last month because I realized it's so short, 2 minutes is so short. The Brady list is sort of this view of examining all the sheriff's officers. And I want to tell you there's two sides that you guys need to consider. And I think everybody is paying attention to how you vote, how your amendments, how you guys work in this commission. And when you're giving the sheriffs a hard time and when you're supporting the public people, there's a big segment of American people who are paying attention to those details, and I'm just one. And you know, if you examine, you know, the sheriff's office, they see such horrible stuff every day, and they see great stuff. And you know, when I pay attention to the way it works on the other side of the coin, we get an illegal alien who's here illegally, clearly broken the law. And in the case of the guy that killed my brother, you know, he's running a red light. He was running a red light so fast, he hit my brother that the coins ripped out of his clothes, the shoes ripped off of his feet, right there in the crosswalk. And this guy was running a red light because he wanted to get somewhere, but he was here illegally. He wasn't paying attention to the laws. And that's a little bit different than a lot of these guys. These guys have all seen so much, you know, and they're here to, you know, when they get hogtied by the rules, by the laws, by the regulations, you know, there are people like me that are paying attention. And I see I'm out of time again, but I'll come back and finish my statement if I got to do it 20 times. You know?
Thank you. Is that it? Okay. All right, so we have a motion. Ready to vote on this motion to adopt the resolution with the amendment. Everyone in favor?
Aye.
Aye.
Any opposed? Unanimously approved, thank you. And so I guess it will be really interesting for us to, obviously, I'm sorry? Somebody say something? It's, I just want to suggest to the Sheriff's Department that we look forward to hearing back from you about this, and what any plans you have, if there's any process that's going to be engaged in, processes you're already engaged in. Maybe you could come back either next month or the month after and just give us an update when you give us updates about how you're responding to our resolution. Okay? Thank you. Okay, so let's move to agenda item 2B, which is getting an update regarding the department's compliance with the Prison Rape Elimination Act. The commission has been monitoring the PREA compliance federal rules since 2017. We have members of the team here today to report back. We have Custody Assistant Division Director, is Karen here? Here you are, there's Karen Dalton, and Deputy County Counsel Tyson Nelson. Thanks so much for coming.
Yes, of course. Well, good morning, Chair Diggins and Commissioners. I'm pleased to be here with my partner, Tyson Nelson, to share some monumental advancements that LASD has made over the past year in the effort to create a sexually safe Sheriff's Department. I'm grateful for the Commissioners' commitment to the Prison Rape Elimination Act and appreciate the support provided through the ad hoc committee.
Okay, so I'm just, as you mentioned, PREA is what we like to call it, is a Prison Rape Elimination Act of 2003, signed into law by George Bush. It's a federal law that mandates zero tolerance for sexual abuse and sexual harassment while incarcerated. There are prison jail standards, there are community confinement standards, and juvenile facility standards. We obviously are dealing with the prison and jail standards. LASD also must deal with lockup standards for their station jails as well too, as we roll down here. It took them 9 years to issue standards, so in 2012 they issued standards. It took them 9 years to figure out the standards. It's just as complicated to implement the standards at such a large facility. The standards themselves are goals. They don't actually tell you how to do it. So we have to come up with I'm sorry if I'm not talking into the microphone. I'm loud enough usually for everyone to hear me without a microphone. So it's really up to us to figure out how do we comply with the law. And that also is a very difficult issue at such a large agency that Sheriff's Department is. So as many of you may know, Sheriff Villanueva gave a directive that he wanted CRDF, the Women's Jail in Linwood, to be audit ready by December 2019. And we have been working seemingly nonstop at CRDF to get that facility ready. The sheriff also temporarily authorized PREA-specific positions at CRDF that have drastically helped us implement the standards there. Now, there are 43 standards. How we have broken it down, originally we grouped them together and we came up with 208 provisions that we have to comply with. The more we broke it down, the more we realized grouping them together is shortchanging all of the efforts that we're doing. And so what we've done now is broken down every standard, provision, and sub-provision down to 320 provisions that we at LASD and as the county need to comply with. 23 do not apply to LASD. Those are ones that relate to auditor qualifications. There's nothing LASD can do about that. There are also medical and mental health specific standards that doesn't apply to LASD, that obviously would apply to correctional health services, and they are a great partner with us working on PREA compliance. And then there are also standards that deal with if you house youth. LASD does not house youth, probation houses youth. So those don't apply as well. And when you break down the 320 further, 98 of them are agency-specific policies, personnel issues, training for volunteers and contractors that happen at an agency level. And then we've broken it down to 199 CRDF-specific standards. Now, there's a little asterisk there. That CRDF itself, as we're implementing a lot of these standards on the ground, they're operating as pilot programs. Eventually, for it to be permanent, there needs to be an agency-wide policy on that. And we are working on that on an agency level as well. So there are certain things that CRDF are doing to comply with it that to get a full compliance at LASD completely, the agency also must enact a policy. There are many PREA policies. We're going through and revising a lot of them to be more specific on how PREA is being complied with. So some people like pie charts, some people like graphs. So here is a pie chart. Of the 199 provisions that are CRDF specific, we've determined that 104 are audit ready. That equals 52% that we feel are audit ready at CRDF. 74 are in progress, meaning that we're working on them. We have an idea to implement it. Some of them aren't being implemented, but they're being modified or changed because they're not working the way we had hoped. And 21 are non-compliant. A lot of those are you have to do A before you can do B, and we're working on perfecting A before we move to B. We truly believe that we can get CRDF audit ready by the sheriff's date. There may be a few stragglers, but we have a plan for almost every single provision. There are a few that we're struggling to how do we do this? And the more people and more brains we put in a room, we're figuring out plans. So if we can't meet that for one or two provisions, we're gonna have a plan and a reason why and our kind of corrective action on that as well. So I just wanted to point out a few of the things that we have implemented at CRDF. A huge task has been screening every single female or transgender male that is brought to CRDF must be what we call PREA risk screening or PREA risk screening assessment. What LASD has done and working with their technology company, Karen and her team worked with them a few years back to create 19 questions that are asked of every single inmate that walk through the door. That has been a very difficult task to add more time on because they're very much conversational questions. And as you know, and I'm sure the commissioners are well aware, that adding more time at booking is not something we're looking for. But this must be done. And this is done so that we can then determine whether someone falls as a possible victim or as a possible perpetrator, and then we have to house accordingly. So CRDF has kicked that off. So every female, transgender male, transgender female that is brought to CRDF is asked these 19 questions in addition to the hundreds of other questions that are asked of them that come through the door. And then they are also then housing them accordingly. So under PREA, you shouldn't house a possible perpetrator with a possible victim. Obviously, you can if there are certain protections in place. But for us, we would like to not house them together. So CRDF is now being creative with how they are housing people specifically throughout their very crowded jail to be able to make sure that they don't interact. That also means that they're not placed together in a module, but then they also don't go to education together. They also don't go to AA together. And that's also a very complicated algorithm to figure all of that out. And CRDF has done a very good job trying to figure that out right now. And it's working. That's a great thing. We've also implemented a comprehensive education program at CRDF that grabs, we say, most inmates, because we are now doing that right at the end of the booking process so that every inmate is aware of all of their rights under PREA, how to get help, how to get services, and how to report. We say most because there are certain inmates that sometimes are essentially bypassed and right into specific housing. Sometimes you're very high profile people that are there. Sometimes inmates that come in that have high mental health needs, sometimes skip the booking process entirely so that we can get them where they need to be. And we are working on, we have a plan to be able to catch those later. The staff training, CRDF has been training staff since 2016. We have gone through and kind of done a quality improvement of that staffing education, and CRDF is rolling out re-educating all of the staff. You're also required every 2 years to give a refresher, and so we're ensuring that those that have not gotten the new rollout are getting the refresher training. So this is an ongoing thing. It's not you just train them once and you're done. It's a refresher every 2 years and then an information bulletin every off year. So they're getting PREA information regularly. How CRDF is doing it, they're giving information on a regular via email, via briefings, so that they're aware of all of the developments that are happening at CRDF. The next two are kind of similar. We've done a massive blind spot assessment. Sometimes you wander around these facilities and you're kind of shocked that they were actually built for a correctional institute because they're built for blind spots. LASD has worked very hard to eliminate those blind spots. Blind spots assessment doesn't just mean cameras or mirrors. It also can mean staffing. It also can ensure that there are no coverings over windows where inmates go, that blinds are open or blinds are removed, all of that stuff. And you, as you know, probably, you remove blinds from an office, you walk by 3 months later, there are now paper put up because a lot of stuff are happening under there that people don't realize that you can't do this under PREA. So it's a constant blind set assessment on a regular basis that doesn't ever end. Also, there are facility modifications that CRDF a lot of them have been done, a lot of them are in the works. Some of them need high level approval because it does cost money, but a lot of them are underway. I was touring CRDF earlier this week, and actually for an unrelated issue that I'm working on, and we saw some of the modifications actually in place, and it was actually kind of an exciting thing to see some of these PREA modifications happening at CRDF. We're being told that all of those modifications can happen by December. Now, obviously, that depends on funding and staffing to be able to get the facilities crew out there to do them. Another huge aspect of PREA is a detailed staffing plan. And I'm going to turn it over to ADD Dalton, who will address staffing.
I just want to say too that with everything that Tyson has brought up today about what's going on at CRDF, we would welcome that one of our future ad hoc committee meetings be held at CRDF so that we can show you what has been in progress. So PREA is big, right? No, really, PREA is huge. And over the past year, the interdepartmental county collaboration and the LASD department-wide collaboration have been growing steadily and gaining momentum. The work that this small but mighty team, PREA implementation team, has accomplished has been very impressive. I want to speak to you today about department-wide PREA standards, or those that require compliance at the department level and are not necessarily facility-specific. They fall outside of custody division, but within the department. These standards include things like our hiring and promotion practices, investigation at the administrative and criminal level, as well as new and renewed contract language and data collection, retention, and documentation, just to name a few. In our quest for securing compliance with the department-wide standards and provision, I must give kudos to the command staff assigned to the various divisions within the Sheriff's Department who have met with the PREA team, listened to the PREA mandates, and worked with us to take action. Information that we have requested on current practice, identifying gaps, and reworking things to create an attainable practice that meets both the needs of the department and the requirements of PREA have been moving forward at the department level. Standard 115.13, supervision and monitoring, requires that each jail facility operated by the department develop a staffing plan. It is known that inadequate supervision is perhaps the single most significant factor and preventable factor to sexual abuse and sexual harassment in confinement facilities. Further, inadequate staffing practices make facilities dangerous for both inmates and staff. Mr. Rod Miller of CRS Incorporated has been a pioneer in comprehensive research into staffing plans and vulnerability analyses. Rod has been brought on as a consultant via our partner Just Detention International to assist in the development of a staffing plan at CRDF and overlaying a vulnerability analysis to not only meet the PREA standard requirement, but to show how addressing the vulnerabilities of the jail through a proper staffing plan can reduce the likelihood of PREA-related allegations and offenses. I would also like to address the identified points of interest to consider as we move through this journey towards PREA compliance. I think we can go to the next slide. First, our department-wide data systems is in dire straits. Needs for upgrades, systems that intersect and talk to one another cannot be understated. Our PREA compliance relies on good and proper data collection. Securing PREA compliance without proper technology and data collections capabilities is nearly impossible. The team has been working consistently to identify means to conducting the reassessments that Tyson referred to earlier, follow-up, and monitoring, which involves every single inmate that comes through our door, as well as those who have indicated or made allegations, those who have reported sexual abuse in other confinement facilities, or at any time for that matter, and technology solutions such as iPads for inmates or electronic means of pushing information out to the inmates is not available, but would be, they're not available, but would make tracking and data collection requirements under PREA significantly less burdensome for staff and inmates. And speaking of staff, when Tyson said they're working feverishly, in addition to their responsibilities for PREA compliance at CRDF, they've been working a tremendous amount of overtime. They're invested wholeheartedly in this project, and they wonder what the long-term investment of this county will be for PREA. They're working so hard at implementation and compliance, but PREA is not based on achieving. It's based on institutionalizing a department with a culture that is motivated in many ways, one by knowing that these efforts will be sustained, which can be enhanced and secured through your continued support. PREA is not an event, it's a process, but one that we feel is worth going through. So I look to you for continued support in this process. Thank you.
Thank you so much. I'm going to open it up for questions. I have a question. Either one of you, Tyson or Karen, can you give us an example of one of the like really tough issues that you were actually able to resolve? Because I know you've resolved some and there are many more to be done and it's quite complex and you have an old facility. But could you give us an example, maybe one or two of like what you had to wrap your heads around and you were successfully able to implement?
Sure. So one of the things that we recognized, well, one of the things that's mandated is that PREA has to offer inmates several ways to make reports, right? So we had our grievance system is in place, which we haven't completely tackled that yet, but we're working towards it. But one of the things that has really been helpful in how we're working towards reconciliation of the allegations that come in is that facilities are now required to fill out an incident alert, and that's for all of our facilities. So that's not just CRDF, but all of our facilities fill out a incident alert, and then that gives the PREA team the opportunity to cross-reference towards any grievances or any other type of report that may have come in from any of the many ways that we've pushed out the capability of reporting. And one of the reasons why that's been so successful is that it's giving us an opportunity to identify where some of our other weaknesses are so that we can work at strengthening those weaknesses. So I would say that's one. I have several I could talk about. So another one would be the comprehensive inmate education. So the PREA standards require that within 30 days of arrival, every inmate receive, well, let me go back. It actually requires that upon arrival, every inmate receive information about how to report and basic PREA information. Within 30 days of their arrival, they're to receive a comprehensive education module that it can't be it needs to be a video, it needs to be live people so they can ask questions, it can't be a pamphlet, it can't be, so there has to be interaction. So one of the things that we have done is we've implemented that comprehensive education. Although it doesn't necessarily meet that 30-day window because we're doing it right away, the inmates are getting that information upon coming into custody. Where before, because we don't have an accurate tracking system for where all the inmates went, we were running around the facilities trying to find this inmate because they didn't receive comprehensive, or that inmate because they didn't receive comprehensive. Again, it was just staff intensive. So doing it collectively at the time of classification, at the time they're being moved through the system, has really helped us and really acknowledged that those individuals are in fact receiving that comprehensive education.
So I can add on to that. I can add one specific to CRDF. So when CRDF had their mock audit in 2017, one of the things that the field training auditor, PREA auditor that came out, detailed is that in certain housing locations at CRDF, the stairs go up on the side, and they're stairs that you can see through, if that makes sense. So it's a step, 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 and there's nothing connecting it. So you can see through it. Of course, how it was built, you're walking right up over top of the shower. And so you can see into the shower as you walk up the steps. How that was approved on a blueprint, I don't know. So they had a suicide door so that you could see up, maybe from about here up, and then you can see basically from knees down. But as you walk up, you could see through. So there were probably 6 or 7 different ideas that we had, replacing that door with something else. We couldn't get that approved with the team that monitors for Suicide Watch because it would cover too much and the staff couldn't see it, so it wouldn't be safe for the inmates. We thought about having an actual shower curtain that's kind of opaque at the top, but then you could still see too much of the body. We had people standing in the shower, not us, not inmates, but us standing in showers as we're walking up and down. I played the role of a short person standing in there to see if they could see different things. Ultimately, what we were able to determine is that for about 5 steps that you could see through, if you put a sheet metal essentially on the back, it blocks it. So when we were there earlier this week walking around with the ROSIS monitor, another one of my county council assignments, I noticed that the sheet metal was up in many of the facilities. And that was something that Karen's team and Karen worked with Assistant Sheriff Olmstead's office to be able to get that fast-tracked. And once we were able to figure out that we could do that and it was safe, because a lot of the ideas were concerning for suicide risk, we were able to get that in there till now that when you walk up the steps, you can't see in the shower. Little victories are exciting.
And one other little victory while we're talking about facility modifications was that we had several doorways that go through the jails. As you walk through the jails, the doors are solid doors that are, some are locked, some are unlocked. But that becomes a blind spot, right? Because although we don't like to think that it happens, it could be that people, take inmates into those rooms and abuse them. So what we did was we are having vision screens cut into those doorways. So we have vision ports that is a window that's cut into those doorways so you can see in, you can see out, and that gives us greater visibility across the facility.
Thank you. I have a question.
Okay.
Yep. I think all of this information and update is extremely helpful, and I congratulate you and your team for moving forward. One of the things I'd like you to briefly address is explain, because it's been a year since you were here, what is the audit that you've referred to and who does it? And what happens if you comply, what happens if you don't comply or you partially comply? So just give a brief explanation for us and for members of the community who may not understand what you're talking about when you talk about an audit.
Right. So two things about the audits in general. So one, PREA mandates that all jails and prisons, community confinements, be audited every 3 years. So what happens is you get into an audit cycle with your agency. So then you have 1/3 of your facilities audited every year. So your department is constantly going through that audit process. And the facility or the agency department, they're the ones that initiate the audit. And it can be done in many ways.
Right, so at the end of the day, the facility must be audited by a Department of Justice certified PREA auditor. And so there are, I think, two in this room currently, Ms. Dalton and Noemi from OIG, who have gone through the extensive training to be able to be DOJ certified auditors. And so those are the individuals that must come in and audit the facility. And then they issue a preliminary report. You have 180-day corrective action. You work with your auditors to be able to fix that, and then the final audit is issued. The audit I referenced earlier was when you're going through the training with it's called the PREA Resource Center, which is a quasi-governmental agency overseen by the nonprofit Impact Justice, but also the Bureau of Justice Assistance of the DOJ. So one kind of issues a legal opinion, one kind of just manages all of the stuff that goes into certifying auditors. As you're going through an auditor, you must do what they call a field training audit. So it's not an official audit to where you can go and say, look, we passed an audit. It's something that's a learning experience for the facility and the agency, and also a learning experience for the auditors. And in 2016, CRDF did go through a field training audit, and that's what we kind of that's what I referenced earlier about they recognized the stare and the blind spots, and they also recognized a lot of other issues that were tackling that CRDF.
Any other questions or comments?
Yeah, just a question. You referenced some of the areas that you were either in progress or non-compliant, in progress. About getting to A before you can get to B. Can you give me an example of one of those?
Sure. Good question. Now that I'm on the spot, I have to come up with one here. Well, actually, one of the things is that, you can't place possible perpetrators with possible victims. So then the first step is you have to figure out who's a possible victim and a possible perpetrator. And so with the questions and the risk screening, they have determined that. And we were on I'll take a step back here. One of our big goals when we came on was to be able to roll this all out at once, to be able to, like, from, on Tuesday, everything PREA is rolled out. As we tried to start building that plan, we realized to be able to do that, it's impossible. And so we had kind of had ideas to be able to figure out how to classify people on the sheriff's system, to be able to keep away this person from this and the possible victim from the possible perpetrator. So we had a plan for that, but we didn't have a plan yet to be able to how to incorporate all of those questions in. So that was very much kind of we had the B plan, but we didn't have A in place yet. So the A of actually asking the questions and developing that data has now launched at CRDF, and now we're able to roll out the B plan of, okay, how do we classify people to keep them separate from each other?
But even before that A, the standards require that your risk assessment is objective questionnaire, right? So then you have to figure out what does an objective questionnaire look like? How do you ask the right questions to get the answers that you need to put the people in the proper housing? So, and I will say too that as we go along in this, we're discovering that there's, we're like, okay, we've got A, B, and C. Oh my gosh, we didn't think about pre-A. We didn't think about, so, we have to go back and refine. And that's what I was saying. PREA is a constant refinement of the things that we have in place. But again, very proud of what the small team has been able to accomplish in such a short period of time.
Thank you.
You indicate that the sheriff has directed your team to be audit ready by the end of the year. Assuming you meet that goal, when would you expect the audit to take place?
So that's a good question. Depending on how the audit is going to be set up, the department will have to request it and then secure the auditor to come in and do it. The audit process, once you initiate the question or initiate the request, and then secure an auditor, or it'll probably be an audit team, likely in our case. Then you do what's called the pre-audit work, then you have an on-site visit, and then you have the post-audit work that goes on. So the whole process takes about 6 months, and then the 180 days to, if you go into corrective action, to correct that.
Okay, thank you. Great. Anybody else?
When we invite you back next year, what's the big idea that you hope you will have accomplished?
I think we both are so happy you asked that question. I think we both have great ideas on that. So I think from my standpoint, of course, I'm in this for sexual safety across the department, right? So I would like to see that we have a system in place that fosters safety for our individuals. What will that look like? That will look like being able to take in allegations as they come in, be able to streamline them through a system where we can matter-of-factly say, without finger counting, right, how our allegations look. It's about giving the inmates the feedback that's required by PREA when they make an allegation, what the outcome of that investigation was. Currently, I'm proud to say, again, one of the hits that we've had is that every allegation that comes in is investigated promptly, thoroughly, and objectively. And we have so many days that we have to get that information out to the individual, so many days that we have to keep them notified if their perpetrator has been convicted or not convicted, whether they've gone to jail, whether they work in the system any longer, and things like that. And that's very hard to do on an individual basis. Without that data system that really intersects, that's done on a manual basis. So I want to come back next year with a data system that really gives us the ability to streamline what PREA was intended to do, by its data-driven standards and provisions.
I can just add one thing, that I hope when we come back next year, we're able to articulate that there are permanent PREA staff for all facilities. That has been a very hard lift. Everyone agrees with it, it's just a hard lift of getting that. And I think once that's there, this is really going to go agency-wide.
We have done time studies with our investigations, and on average, one allegation takes approximately 8 hours, up to upwards of 8 hours to complete. And why is that? Because the standards require a prompt, thorough, and objective investigation. That means that you can't just go talk to the inmate and say, well, you know, I don't know, I didn't get that vibe, it didn't seem right. It's talking to the victims, it's talking to the witnesses, it's reviewing our DVTEL. That takes such a long time because people want to say, oh, the inmate said it happened at 11 o'clock. So they go in and they target 11 o'clock on the DVTEL, but the clock is 2 hours off. You know, so what they may think is at 11 o'clock here is really 1 o'clock, and so we have to go back and talk to the investigators about the importance of looking, you know, holistically at the allegation that came in. So expecting that staff do the PREA requirements as a collateral really does not work because other things come up, emergencies come up, things get put on the back burner. This is important enough to make it full-time dedicated for staff.
Great. Do you envision CRDF being the trauma-informed model for the rest of the facilities?
Thank you for asking that question. So we're very grateful to the Board of Supervisors for also allocating some gender-responsive staffing for us. And our goal, our overarching goal, is that we're going to be taking the gender-responsive staffing that we have. We've acquired the Moss Group to work with us on doing training about trauma-informed care, as well as doing an assessment from a gender lens with regards to CRDF. And yes, that is our ultimate goal because PREA and gender-responsive issues really intersect, and we want to make sure that that gets folded into our model.
Okay, thank you. Anybody else? I just want to thank you on behalf of the ad hoc committee, on behalf of all of our commissioners up here, for your amazing dedication to creating a as you call it, sexually safe environment and facilities. And both of you, I know, have a eagle eye on the care of those inmates. And I want to also extend to the other leadership at the department. And Under Sheriff Murakami, would you please extend our appreciation to the Sheriff at Villanueva on his support for all these efforts that are continuing. I think this is such an important topic, obviously, prison rape, to make happen in our county. It took them, as you said, you've seen how complicated the federal law is and understanding what it really means on the ground. And thank you both for your leadership, and we really look forward to supporting your progress.
Thank you.
Thank you.
Thank you.
And now we'll turn to public comment on this item.
We have 3 speakers. Our first speaker, Doreen Sanchez, followed by Rev. Regi Bunch, followed by Michelle Infante.
Good morning. My name is Doreen Sanchez. I'm an Eagle Rock Neighborhood Council Director of Arts. For a victim/survivor to have somehow survived the streets and their lives and then now find them in a system that systematically has been proven also to victimize women, I want to go on the record to request that you consider including training, cultural training, and the cultural needs of the generation of our first people in the prison system. I hope when you come back next year, you have included significant cultural needs, significant cultural training for, once again, the generation of our first people in the prison system. Thank you.
Thank you.
Luigi Bunch, followed by Michelle Infante.
Good morning, Sheriff Civilian Oversight Commission. I think it's a great time to be talking about PREA. However, I'm not too confident in the fact that a jail can provide safety for women and that male sheriffs are a symbol of safety, particularly for women. In July 16, 2019 of this year, from 2008 to 2015, that being 3 years ago, over 87,000 women were sexually harassed in LA County Jail. From 2008 to 2015. PREA now comes in behind and cleans up that mess. Can PREA stop a culture? Because rape doesn't happen because a man rapes someone. Rape happens because a culture exists. Policies exist. A hush-hush silencing exists. People, men who sit in high offices, control that climate. Sheriff Villanueva hired a man who who DV'd his own wife. And I understand how PREA needs to be implemented, but I think the undergirding question is, can women truly be safe inside of a jail, separated from their communities? I think PREA should have another point that is diverting these women away from jails and into their communities. Thank you.
Michelle Infante.
Good morning, Commissioners. First of all, I'd like to thank you for this year, 2019, for all the hard work and everything that you've done. I know I appreciate it greatly, and I know that the community also appreciates the work that you've done. First of all, I'd like to ask, who are these men or women that are going to be on staff for PREA that are going to be overlooking these complaints, these sexual assault complaints against these men inside the jail? It's not women that are raping and sexually assaulting women inside the jail. It's your men that carry a badge and a gun and that are wearing your uniforms. Who are those people? Are we going to do an assessment on them to find out if they have any problems against them? We need to find out these people that are going to be staffing PREA and the people that are going to be looking at the complaints. We need to take a good look at them to see what they've been involved in their life, because there's absolutely no trust in an institution that houses women, and the very people that care for those women and have their safety are nothing but men, and they're the ones that are raping the women inside. I can't tell you how enough it angers me to come up here and listen to all these great policies and procedures and PREA, but you be the individual that was housed inside that place for 6 months, having no place to go when you've been sexually assaulted, having a system that doesn't work when you file a complaint, and the very people that pick up the complaint and that are going to be looking at those complaints are men. So I would suggest to you that you ask and find out who are the people that are going to be assessing those complaints, because more than likely it's probably men, and they are the ones that are raping women inside that facility.
Thank you.
That's it.
Okay, well, I guess we're scheduled to take a break a little earlier than usual. So why don't we do that, and we'll be back in 15 minutes. Thank you, everyone.